Before the court is the Unidos people and their motion for a preliminary injunction, and for the reasons that follow below, the court will deny their motion. So goodbye. Thus, even in the absence of the information sharing memo between the IRS would be required to give it to them. And so they cannot win.
You cannot body slam, body ram, shove, strike, or otherwise
belly
assault
bounce
a law enforcement officer. Everything is still on the table.
A federal judge gives the thumbs up to Trump's plan to track down illegals using IRS data. This caused a lot of people to flip out. You can't access their private data. They got rights and all the things. But a judge disagreed. Now, this is the case involving a lawsuit against Scott Bessent. Since, he runs the Treasury, they got a lot of that IRS data over there. And it was brought by Centro de Trabajadores Unidos because they, I guess, can do whatever they want in our country. I don't even know what kind of organization this is or whatever, but it's not even in English, for crying out loud. And they're suing, which is just perfect. So we'll go through the order that came out of Washington, D.C., which is a nice victory there. But here is what the background looks like over from CNN. They say a federal judge not going to block it. It's a highly controversial initiative that says Trump is going to share highly sensitive taxpayer information with federal immigration authorities in hopes of tracking down undocumented immigrants and getting them out of here quickly. The judge's name is Dabney Friedrich. On Monday rejected arguments from several, I guess, Spanish-speaking groups, from several immigrant rights groups. Yeah. And they claimed that the data sharing agreement violated confidentiality rules. Oh no. The decision's obviously a big victory for Trump. Just gonna say, oh yeah, here's all the information for all the illegals. We got tons of spreadsheets, and so here they are. And go and find them. This is what the order says. All right, look, from the judge. The plaintiffs called Centro de Trabajadores Unidos and Immigrant Solidarity du Page and Somos un Pueblo Unido and Inclusive Action for the City. All of these groups super in interest of American values and other things bring this action seeking injunctive relief. Don't you dare let the IRS share personal tax information with Homeland. The judge says, well, before the court is the Unidos people and their motion for a preliminary injunction, and for the reasons that follow below, the court will deny their motion. So goodbye. Now, the IR code, the Internal Revenue Code, writes the judge, here's why, requires taxes to be paid on all income earned in the United States, regardless of the status in this country. Pay your taxes. Saying the United States citizens file taxes using Social Security numbers. Non-citizens generally cannot get socials, but we know they can because we heard all about that from Doge. They just handed them out to everybody. So they typically register with the IRS to get ITIN number, individual taxpayer ID number. Now, to do so, the registrants must provide their full name, address, and other ID info. Under the tax code, those records are kept confidential and may not be shared outside of the IRS unless a particular statutory exception applies. Now, as is relevant here, one such exception allows the head of any federal agency to request tax return information to aid in investigating or preparing for other proceedings to enforce designated criminal statutes. Obviously, right? Section 6103, I subsection 2 says, nope, one thing you can do, don't share it outside the IRS unless it's to someone else who needs it to enforce the law. Oh. The agency head must first submit the request in writing and must specifically identify the name and address of the taxpayer, the relevant taxable periods, the basis for the enforcement proceeding, and the need for disclosure and more. Now, the illegal organizations who say you can't access our data, they allege that Homeland is seeking access to try to locate and remove illegals in violation of 6103. Now, what they say is here's why. They say there's a bunch of these news articles saying that they're looking for at least 700,000 illegals, which is like, 1/20th. As alleged, that request was denied. But according to certain media outlets and other sources, the acting IRS commissioner is, quote, negotiating an agreement with Homeland that would reportedly is close to terms. Now, under this agreement, the IRS would, they say, unlawfully provide info that could be used against illegals for civil enforcement proceedings. They say you can't do that. Now, judge writes, so on April 7th, the agencies in the Trump administration, they entered into a MOU, a memorandum of understanding, which said, all right, the law, U.S. code says the following, and here's what we're going to do to comply with the law. The memo says the purpose is to establish a mechanism for enabling requests for addresses of persons who were subject to criminal investigation. So they're alleging, saying they're going to go after them for civil stuff. They say, no, we're not. It's only for criminals. Consistent with the law, the head of Homeland, right, according to the memo, must first submit the written request to the IRS. IRS. That must then satisfy the statutory requirements for disclosure, and then only then can they exchange. So it's more like an individual case-by-case basis, right? Rather than a blanket request. Now, the 4 nonprofit organizations are here. They're representing the interests of immigrants against you, Americans, who say, actually, we don't want illegals here anymore. We voted for it aggressively. So you've got these organizations called Center of United Jobs in America, I guess, not jobs in their homelands. Immigrant Solidarity, DuPage, and they can have their solidarity back home. And they're located in Illinois, and they're working to build immigrant and worker power in our country. So illegal power in our country, and to advance the dignity of the workers. Because if you say we don't want illegal aliens in our country, apparently you're attacking their dignity or something, which I don't understand that at all. No, we're upholding the law. They attack our dignity by crapping over our laws. How about that? Some Un Pueblos Unidos is a Santa Fe, New Mexico nonprofit that provides education and legal support to communities in New Mexico, including immigrants. And Inclusive Action also provides low-interest loans to entrepreneurs, including immigrants with ITINs. So helping them establish a bigger foothold and ultimately have, babies who get citizenship and then, make them stay and so on and so forth, and just wipe out the whole demographics of the country, obviously. The plaintiffs seek to enjoin the IRS from disclosing tax information to Homeland pursuant to the agency's agreements. Now, the judge says, we're here at an injunction status, and we know there's 4 factors that you have to analyze, and the court is going to begin and end it with this one. Very simple. Are we going to win on the merits if you're one of these illegal organizations? Now, to succeed on the merits, they got to show that they're going to win, and they have to have actual standing. And to have standing, there's a bunch of things you got to check off. You got to have a causal connection to the injury. When an organization like these Somos Unidos people, when they sue on behalf of their members, they got to show a bunch of things. Now, 3 of these organizations say we're suing on behalf of our members. They say that their members are going to be injured by this. If Homeland gets our IRS information, or if there's civil enforcement, then we could have all of our reliance interests. Okay, so this is a phrase that you're going to hear a lot of. Reliance interests, right? In other words, the illegals relied on the status quo. They relied on non-enforcement of the law, and because they relied on a non-enforcement of the law, that gave them a right. That gave them an interest legally that they can claim, make claims around. You can't just take that out from under us. I was relying on you not enforcing that forever. Now you're enforcing it. Now I'm totally screwed. Well, we warned you. Now, to assess whether they have standing, the court will assume, let's just say, that the IRS violates the law. Okay, let's just say that it does. So if it does violate the law, can you sue to remedy that? Like, do you have a claim to address that? For the reasons below, they say all 3 plaintiffs do have associational standing to challenge whether they acted arbitrarily and capriciously, and they have standing to challenge the lawfulness, right? So they do have standing here. Now, unlike the temporary restraining order stage, they say there is an imminent risk. The court now has the benefit of the memo, which authorizes the sharing of certain returns, and Somos is an organization that represents a lot of illegals, and they intend to share information that's probably going to go after their members. And so that is an injury that is traceable to their interpretation, and so therefore they have standing. So next is about Homeland's use of this for civil enforcement. They claim, well, if the IRS comes, they're going to attack us civilly. The court agrees that civil enforcement would be an injury because the law doesn't provide an exception for that. But none of the organizations have established that a civil injury is imminent. In fact, the memo explicitly says criminal, explicitly, and the law says there's an exception for that. Now, even so, they argue it's not plausible that they're going to conduct individualized criminal investigations, right? They're giving away the game right here. The illegal organizations, if they can just force you to make you go case by case on these things, they know you'll never be able to do it. There's too many illegals. Homeland comes back out and they say, okay, fine, we'll go case by case. We'll go through all 700,000. They say, no, that's not even plausible. You don't have the resources to do that, and therefore you shouldn't be allowed to do it individually either. For support, they rely on a newspaper article. They say, well, Homeland is looking for 700,000 or even 7 million, which is a better number. And they also point to another executive order where Trump said, do this right now. But the judge says, look, okay, that's it. So you think that there's a couple newspaper articles so we can presume that they're just going to round up 700,000 people or something? We can't assume that. We can't just presume and take your position on this. The memo is clear. It authorizes the sharing of information only for criminal investigations, and it affirms that multiple times. The representation by the government at the hearing said the same. Counsel for the government unequivocally assured the court that if the IRS got a request from Homeland for civil stuff, it would be denied. They also confirmed that should Homeland decide to abort the criminal investigation and exclusively pursue deportation, Homeland would not be allowed to rely on that information and would have to return it. So they haven't shown that there's going to be any injury here. And based on their claims, that is not sufficient. But they do have standing to show that the IRS acted arbitrarily and capriciously in reversing its position to share data. Now, the plaintiffs offer declarations that their members relied on the IRS's past assurances that the information would not be shared. They fear, well, we filed our information, now you're going to use it against us? If the IRS reverses course, they say that they're going to suffer injury. The injury is traceable to the change. And so the court will now ask about this. Was the change arbitrary and capricious, or could the IRS make this change? In sum, the judge writes, they have standing to challenge this on various reasons. But for the reasons above, all of the plaintiffs, all of the illegal organizations, including the IAC, lack standing as to the civil purpose of this. So that claim fails. Now, turning to the merits, writes the judge. The illegal supporting organizations argue that the information sharing between IRS and Homeland violates the law. They say you're acting arbitrarily and capriciously. There's no basis for this at all. According to them, they say the law does not allow the IRS to disclose only addresses to Homeland as the memo provides. And they say that it constitutes a change in policy and it's not considering the reliance interest, right? They came here and they were filing taxes and relying on no one enforcing the law. So you have to keep that going for them. But the judge says the court disagrees. In fact, the law mandates that the IRS disclose information if Homeland complies with the law. And so they have to give it up. Thus, they cannot show that they're going to win. This is ridiculous. The court begins as it must with the law. Takes us right there. 6103 I-2 says the IRS can share limited tax information with other agencies for criminal things. To obtain that information, they got to do a bunch of stuff. Submit a written request and more. If it meets the rules and it meets the requirements, the IRS must comply with it. Must. It says the secretary shall disclose the requested information. They have no choice. They have to. So you will have to lose. Not all tax information, however, can be disclosed under the law. Certain information can't be disclosed. And despite this broad prohibition, the memo outlines procedures that are in total compliance of that. It also explains the purpose is to establish procedures for other investigations. Now, the illegal lawyers concede that the statute requires the IRS to share certain information, but they say you have to give more information, not only the address. They say the provision authorizes the IRS to disclose an address only when it's relevant to the criminal investigation as an address needed for the investigation. But they say, no, sorry. That doesn't comport with the law. By its plain language, the statute mandates that the IRS share a name and address with another agency, as long as its request for information is complete and valid and meets the rules. The court cannot read additional restrictions into this, and so resisting this conclusion, they then turn to two other IRS publications that say you can't give out addresses, but the meaning of all of those things are totally unclear. For one, the manuals also that you referenced, they're not the law. The law says this. You can have a manual that says whatever you want, but the law says that. And for another, the court is not obligated to defer to the IRS's interpretation of the law. I'm going to interpret the law. Plain language of this allows Homeland to get the address when they follow the request requirements. They further argue that the law cannot be used to locate individuals because you can only use it for fugitives, like actually charged people. But to obtain this under these rules, yeah, if you are a fugitive, yeah, that's true. But you get a lot more information, right? You get a lot more extensive stuff anyways. Now, they also invoke historical context to say, well, earlier versions and other legislative history and a bunch of other stuff that's not in the statute, you should read into the statute. But the judge says, I don't really need any of that, right? I don't need to see all of that stuff. Okay, the text is very clear. Taxpayer address information is exempt. All you need is a valid request. It's clear. Now, they also then question the reasonableness of the interpretation. At the hearing, they say there would be no reason for them to request this info if the agency already had it. But they say, actually, yeah, there are many reasons why we might want this info. For example, if they're 90 days past a removal order, or if they've re-entered the United States or more. But putting aside all of that, the court's duty is to exercise independent judgment in the meaning, not in the reasonableness of the decision. What does the law mean? Under the law, the IRS must comply with the agency's request for information. Must, as long as they have met the requirements, and they have. Thus, even in the absence of the information sharing memo between the IRS would be required to give it to them. And so they cannot win. Now, they also claim that this was arbitrary and capricious by changing its position. You can say they're kind of all over the place, but the IRS documents can be read another way. You say the manual says this and now they're doing this. It's like a lot internally incongruent, but these memo don't bar anybody from doing anything. And in other words, you're reading too much into that. But even assuming the IRS has changed its position, the type of policy change is not actionable. IRS manuals are not binding rules. They're just policy statements. This is true here because it does not give the IRS discretion to override the law. If the law says you have to do it, you got to do it. Once the request is made, it shall be disclosed. Any change under the memo cannot override the power of the statute. And so, at its core, this case presents a narrow legal issue. Does the memo of understanding between the IRS and Homeland violate the IR code? It does not. The law mandates disclosure under circumstances as outlined in Kristi Noem's memo. And so for this reason, the Unidos Somos Pueblos Trabajadores, they all lose because they have failed to show that they're going to succeed on their claims, and they can go trabajadores back home. Now ordered that their injunction is denied, signed by Dabney L. Friedrich in Washington, D.C. So a very nice order from her. And what's going to end up happening is the deportations will continue. And we had this conversation with Trisha over from Homeland, and she was giving us some details on what is coming next if there is more ruckus outside of these ICE detention centers and these Congress people go bananas.
That this mayor who's running for a higher office wanted his 15 minutes of fame, and he's willing to do it on the backs of our law enforcement officers. By trespassing, by storming that facility, he put our law enforcement officers at risk, he put our staff at risk, and he actually put the detainees themselves at risk. But what I would like to ask the mayor is, who does he want out of that facility? Is it the MS-13 gang members? Is it the known terrorists? Is it the child rapists? Is it the murderers? Which of these heinous actors does he want out of this detention facility?
That's a really good question. Now, you recently hinted that there could be additional arrests made in this protest. There were 3 Democrat members of Congress that were also allegedly there, allegedly stormed the facility and got into a physical altercation with federal agents. Do you see any of those members of Congress possibly being charged?
Members of Congress and any public official is not above the law. You cannot body slam, body ram, shove, strike, or otherwise
belly
assault
bounce
a law enforcement officer. Everything is still on the table. I'll leave that to the Department of Justice, but it is despicable to watch members of Congress assault law enforcement, and we will do everything we can to protect our brave law enforcement who so bravely operate this facility, and we thank them every day, Mark.
All right, so they now have thumbs up from the judge to use the addresses to go arrest people and increase the capacity and the population at those facilities. And if there is more interference between the two, there will be repercussions.